The Supreme Court has decided not to take up the case regarding Montana's law that mandates parental consent for minors seeking an abortion. This decision leaves solidly in place a ruling by Montana's highest court that nullified the law. Introduced in 2013, Montana's statute made it illegal for any doctor to perform an abortion on a patient under 18 without obtaining notarized written consent from a parent. The state's Supreme Court ruled that this legislation was unconstitutional because it clashed with broader constitutional protections for abortion rights provided by Montana's state constitution, a stance that goes even beyond those safeguarded by the U.S. Constitution. However, the Supreme Court did not issue an explanation for its decision. Conservative Justices Samuel Alito and Clarence issued a brief note suggesting that procedural issues rendered the case a poor fit for addressing the fundamental questions surrounding such laws. They emphasized that the refusal should not be interpreted as a dismissal of the arguments presented in the appeal. Montana officials argued that the authority granted to parents extends to all medical decisions about their children. They claimed that as long as parents typically act for their child's best interest, the state should not interfere or question their capacity to make the right decisions for their minor children unless there are reasons to deem a parent unfit. Planned Parenthood, which legally challenged the law, argued that the case primarily centers on the state constitution. They criticized the Montana officials for assuming that parental rights were the only consideration and that no additional rights need to be taken into account. Under Montana's law, a doctor who performs an abortion without parental consent would face substantial penalties, including fines and possible jail time. The law also permits a minor to request a court decision if they believe they are mature and knowledgeable enough to make the decision independently. The Supreme Court had previously confronted a similar issue in the 1970s, shortly after its groundbreaking decision in Roe v. Wade in 1973, which established a woman's right to choose an abortion. In the 1976 case of Planned Parenthood of Central Missouri v. Danforth, a majority of the justices had dismantled similar consent provisions, partly based on the constitutional rights established by Roe. Subsequently, a 1979 ruling invalidated a Massachusetts statute because it lacked an option for minors to seek a court's approval to bypass the parental consent requirement. Montana contends that the Supreme Court's decision to overturn Roe 3 years ago fortified its legal reasoning, particularly as state courts recognize a similar right to abortion within Montana's constitution. This contrasts with the court's remarks in Dodds v. Jackson Women's Health Organization, where it declared Roe's reasoning egregiously wrong. In its critique, the Montana Supreme Court accused the state Supreme Court of disregarding long-established principles of parental rights, arguing that parents' fundamental rights do not encompass knowing about or having a say in their minor child's crucial medical decisions, particularly when it comes to abortion. The state court upheld that minors, much like adults, are entitled to a fundamental right to privacy. This right includes the ability to make reproductive choices and to make medical decisions concerning their bodies, in collaboration with a trusted healthcare provider free from governmental interference. What do you think? Does the right to parental consent override a minor's right to privacy and self-determination, especially when it involves medical decisions like abortion? Share your thoughts in the comments below.